Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. Today we will discuss an important topic concerning probable defense and probable defense. I will emphasize on section 20 of PC8, section 7 of PC8 to make this topic more effective for you. If you are a defense lawyer or a client facing a false ACB case, in that scenario the content is quite useful for you. I want to clarify that whenever you are having a case under section 7 or section 11 of PC8, the big trouble for you is section 20 of PC8. Because by the virtue of section 20 of PC8, the court may draw presumption against you. It is basically a negative thing against you. In that scenario, it is easier for the prosecution to convince the honorable court that it is a fit case where accused is liable to be prosecuted and convicted as well. So we have to work out on the same and we have to understand the basis. For this, we are having two important theories, the theory of probable defense and the theory of probable defense. First, we will discuss on theory of probable defense. For this, we have to study section 7 of PC8. In section 7 of PC8, we are having the common elements. That is, the accused must be a public servant. There must be a public duty to do or to forbear the same. The accused had obtained or accepted or attempt to obtain undue advantage either for himself or for any other person. It is totally immaterial the source of execution. It can be done by public servant or he may cause another public servant to do the same. Please be noted. So by the bare perusal of section 7 of PC8, it is quite clear that it is applicable only when the accused is a public servant. For example, you are a private person and there is no public servant. The primary question arises whether you would prefer to face the trial. I think that the answer would be in negative no. Because if you are not a public servant, you are a private person, in that scenario it would be foolish to fight the case on trial basis. In that scenario, we have to raise our defense before Honorable High Court in the form of quashing petition that is usually filed as per section 5 to 8 of BNSS or section 482 of CRPC. In that scenario, we are totally able to head the case of prosecution on point that it is basically abuse of process. In that category, we are having a probable defense, means a defense that is inter alia, providing us a capability to head the prosecution directly without any worry. So whenever we are able to establish the fact that the process inter alia is abuse of process, in that scenario we could inter alia request the honorable court to quash and set aside the impugned proceeding. Apart from that, for section 7, demand is sine qua non. If demand is not on record, even though we are having a positive FSL report against us, in that scenario even we can move before Honorable High Court for question. On that point, we are having important judgment of Honorable Bombay High Court, that is Dada Sahib versus State of Bombay. Judgment date is 27th of November 2024. But in probable defense, we have to wait till the trial initiation, because in the trial the concerned prosecution has to prove that the accused had accepted or obtained or attempt to obtain undue gratification in term of section 7 or section 11. If the basic elements are proved, in that scenario the prosecution would have a prima facie case. The burden to prove the contrary is on the accused. If accused failed to discharge the burden, in that scenario he could be convicted with the help of section 20 of PC8. But to rebut the presumption, it is not required for you to prove your defense beyond reasonable doubt. For this, you may raise a probable defense. Please be noted. For example, if Mr. A says Mr. B inter alia demanded money for installation of electric meter. In that scenario, for doing a public duty improperly or dishonestly, Mr. B had demanded the undue advantage. This is basically a fact. But once this fact is established in that scenario, the court will draw the presumption. And to rebut the same, we have to emphasize on the theory of probable defense. Mr. B might have three theories in this case. He may sustain that the work is not pending, number one, or there is no demand. Number three, there might be a recovery, but the key point is that Mr. A inter alia visited the premises. He thrusted the money inter alia. Team had come and I was compelled to count the currency notes, and that's why the phenolphthalein powder was inter alia, came into touch with my skin, and the same resulted in a positive phenolphthalein test. In that scenario, he could be succeeded to raise a probable defense. So I request all of you, whenever you are going to study the case of Prevention of Corruption Act, you have to emphasize on multiple facts and scenarios. We have to emphasize on defense theories as well, and from the inception we have to be very much alert. It is usually seen that the concerned accused failed to give the proper representation. If you are not giving the representation, in that scenario you are going to play with your own case. Because whenever you are going to raise the probable defense and the concerned authority are not willing to investigate the case, in that scenario you may raise the point of unfair investigation, which is also part and parcel of probable defense. Apart from that, if we are having the material points which are raised but there is a delay in doing the investigation, in that scenario we can raise the probable defense and request the Honorable High Court to quash the proceeding on ground of extraordinarily delay. For this, you may note the judgment of Honorable Supreme Court, that is Vakil Prasad versus State of Bihar. Judgment date is 23rd of Jan 2009. That is very important point. And apart from that, pendency of work, competency of work, demand, the point of voluntarily demand, the principle laid down by Honorable Supreme Court in case of Neeraj Datta versus State of NCT. Judgment date is 15th of December 2022. Might be the good grounds for you to raise a proper probable defense looking to the facts and circumstances of your case. So whenever you are going to study, raise a proper defense theory, submit the proper representation. In case it is not considered, you may raise the same as a point of defense, means in the category of unfair investigation, to have the proper success in your case. Even though you are not discharged by trial court, but it doesn't mean we are going to leave the material points out of the syllabus, because whenever they are having a case against us, they are having appropriate evidences, for example report, FIR, pre-trap, trap, and what we are having? Nothing. We are going to submit our submission verbally, but it is not sufficient. You have to do the proper documentations so that in case they are coming in the witness box, you may do the examination in the light of certain facts like pendency, competency, demand, voluntarily element. Apart from that, we may also challenge the sanction in light of judgment of Honorable Supreme Court, that is CBI versus Ashok Kumar Agarwal. Judgment date is 31st of October 2013. So these are the important points for your consideration. See you in the next video. Till then, Jai Hind, Jai Bharat.